Hey, it's Stacy. If you are enjoying Tell Me What It's Like and you want to help support this show as you're getting ready to listen to this new episode, go into your podcast app and rate and review this podcast. It really does mean a lot. Thank you and enjoy the episode. This is Tell Me What It's Like, a show about life-changing experiences and the perspectives they shape. I'm Stacy Rain. James Porfido spent 8 years as a prosecutor after getting his law degree, working hard to put accused criminals behind bars for their crimes. Then he switched sides, so to speak, and instead of prosecuting the accused criminals, he began defending them, and he's done so for nearly 30 years. James, welcome to Tell Me What It's Like.
Thank you, Stacy. Thank you so much for having me on, and I appreciate the opportunity.
I'm so excited to learn from you today all about the justice system. Let's start by quickly talking about your background. I know you had this switch from prosecution to defense, but there's a lot that goes into law. So let's give us a quick overview.
Sure. So after graduating law school, I actually did a 1-year clerkship with a judge in the Superior Court of New Jersey. And our practice area, or the concentrated area, was family part. So I learned a lot about domestic violence cases and juvenile delinquency, which are young adults, let's say. They're not quite adults under the eyes of the law. Anyone under the age of 18 that commits a criminal offense is a juvenile delinquent. And those offenses came before the family part judge. And then from there, I worked as an assistant prosecutor in the Morris County Prosecutor's Office in New Jersey. And I started there in 1989. Mm-hmm. And I worked there up and through 1997. And I kind of rose through the ranks there, and I was very anxious to kind of want to try cases before a jury. That was my passion and my interest. So I went through the various levels in the prosecutor's office, and ultimately I became the head of sex crimes and child abuse and vehicular homicide. And I was handling a lot of high-profile cases through the years that I was there, and a lot of them resulted in jury trials. So I got a lot of experience and became very comfortable picking a jury and trying a case and telling the story of the prosecution of the accused and really presenting the evidence to support the convictions, or my desired outcome was a conviction.
Yeah.
Certainly on the defense side, it was not that. So I became very comfortable with that, and it really was something that carried through to me. It was very resonant with me, and it's something later on, even now, that became so important as far as storytelling, because I teach a law class now at Seton Hall University Law School, where I went undergrad in New Jersey, and I teach a class called Persuasion and Advocacy, which is really the dichotomy of a trial. It's really about delivering an effective opening statement, direct examination of witnesses and cross-examination of witness, introduction of exhibits into evidence, giving a good, effective closing argument, and ultimately, how the court structures, the rationale as far as the instructions and ultimately the verdict in the case. But getting back to my years in the prosecutor's office, I was prosecuting vehicular homicides, and I did a particular case where a young mom was killed by a drunk driver, and he was more than 2 times the legal limit. And he was driving well in excess of 85 miles an hour on a local highway. I'll say a highway. It wasn't really. It was 2 lanes in each direction. So it wasn't a major highway, but this young mom was killed, and I got to know her husband, who was an attorney. And at the time in New Jersey, this is 1994, the laws effectively had and they still do have a death by auto statute, which is really a low degree of a crime. And in the big scheme of things, it was a 3rd-degree offense, and it carried a maximum, if someone had no prior criminal history, of 270 days of county jail or 270 days of community service. And when I explained that to him, he said, look, my wife is dead, and the outcome, regardless of whether it was a vehicle or a gun or a knife, it's the same. And I agreed with him. And I said, well, we'll do everything in our power to prosecute this individual to the fullest extent of the law and under the traditional laws that existed at the time, where he was indicted for aggravated manslaughter and went to trial and ultimately was convicted and sentenced to 20 years in state prison, 10 years without parole. And this father he made a promise to his dying wife before she was removed from life support that he would do everything in his power to see that another family didn't experience what he experienced, and that the justice system needed to be changed. And he effectively was able to get the laws changed in New Jersey, and the laws were named after his wife, Terry's laws. And in 1995, they were enacted, and vehicular homicide now carries a mandatory state prison sentence of a minimum of 3 years. So he kind of changed the whole dynamics of that. Well, fast forward a couple of years after the trial had concluded and the laws had been changed, he was out jogging near the site where his wife was killed, and he tragically was hit by a car and killed. And he had started a foundation, and he was speaking to high school students about the dangers of drinking and driving and being a passenger or a driver in a vehicle. And he was really the sole spokesperson for the organization, the foundation. I left my job as a prosecutor, and I took over his position on the board. And I spoke to about 77,000 high school students over the period of 2 years about his message that he was trying to deliver and was effectively delivering throughout the state of New Jersey.
Yeah.
And then I became a criminal defense attorney. And, the first year or two, I was just kind of finding my way in a small family practice. My uncle was an attorney. I joined his firm as a junior partner, and I was doing a variety of different cases, but I always had an interest in criminal law. And that's really where my experience was. So ultimately, I started to handle much more high profile criminal cases, and I was the defense attorney and simply shifted from one side of the courtroom to the other, from one counsel table to the other, but the laws were so different. And the same judges that I appeared in front of that liked me as a prosecutor didn't like me so much as a defense attorney. So I started to see that the system was a little bit imbalanced, that the scales of justice were a little bit tipped more towards the state. And I didn't recognize that as a young prosecutor. I just thought that's the way it was. But realized later on that we had a lot of unfair advantages as a prosecutor representing the state. And the accused, those charged with those criminal offenses, they really had a difficult road ahead of them, because I found that when I was representing people in that situation, they were almost guilty until you could prove they were innocent, which is really not what our system is. Our system is innocent until proven guilty. So that kind of led to some other things. I became a TV legal analyst shortly thereafter, and I've been doing that for a number of years in different forums, whether it's TV or whether it's media on podcasts or radio. And I've done some high-profile cases over the years. I was on court TV quite a bit, probably the first 13, 14 years, doing a lot of cases like O.J. Simpson and the Menendez brothers and Scott Peterson, Robert Blake and Phil Spector, and all these cases that were in the news, that the people had an interest in and a fascination with. And I became very comfortable on air speaking on camera about these cases and about the roles of the attorney and the evidence in the case. And that's kind of what I was doing, in addition to practicing law, of course. And my defense practice took off, and I started to handle a lot more high-profile cases through the years. I became a certified criminal trial attorney as I was ending my tenure at the prosecutor's office. I became a certified criminal trial attorney, certified through the Supreme Court of New Jersey. And that certainly gave me an additional level of credibility, I'll say, in the defense world as well, and brought clients to me. And
what does that mean to be a certified?
What it means is that you've held yourself out. You've concentrated in that area of practice. You've attended classes and seminars, and you've taught, instructed on these particular areas of law. And you've tried cases, and you've had a volume of cases where you've actually gone to a jury trial, or you've litigated the case to a pretrial stage, or you've done applications or hearings before the court. You've had bench trials or jury trials. So you have to hold yourself out and distinguish. It's a whole process. And I'm happy to say I've been continuously recertified since 1995. And I think I have one more time to go. And my
fantastic.
certification will be up in 2026, if I'm not mistaken. This is this year. No, it's next year. So I have one more time to do it, and it's good for 5 years.
Ah, gotcha. That is quite the background, and I have many questions. I'm about to argue with a lawyer, which is probably not smart. But you said you just simply switch sides. How do you just simply switch sides from prosecution to defense, especially when you have this stint in the middle where you were working for a foundation that was started because someone said this person needs to spend longer paying for their crimes?
Yeah, well, in the beginning, I'll be frank with you and honest, and I didn't handle DWI cases, driving while intoxicated offenses. I specifically stayed away from them, and I would conflict myself out of those cases because of my involvement with the foundation. I felt I had a bit of a conflict. And I would disclose that to clients and say, look, I don't think I'm the person to represent you. But then as time went on, and, I was involved with the foundation for about 2 years, 3 years almost. And then I started to take on these DWI cases, and throughout the course of my career, handled thousands of them. I mean, literally thousands of DWI cases, and became very good at it and
so
proficient
you do
at
that
it.
now. So you defend them.
Now I'm of counsel with the firm. We have 65 attorneys. I'm not actively practicing. I'm consulting with the firm. And of course, I have the adjunct law professor position that I do. And I'm also a legal expert affiliated with the TV station as well right now.
Yeah. But meaning you did eventually defend DWI cases.
I did. Yes, I did. And it was a tough pill to swallow. But I specifically, and throughout the course of my career, never handled a vehicular homicide case.
Gotcha.
One of the last cases I actually handled was a vehicular homicide case when I closed my private practice in 2023. And I became of counsel with the firm that I'm at, which is Einhorn, Barbarito, Frost, Botwinick, Nunn, and Musmano.
That's a lot. How do you remember that?
Yes. And we have 65 attorneys, and I'm in their criminal section, and I'm really just consulting.
So other lawyers can come to you and say, here's what I'm thinking.
Correct. And we have 3 attorneys that are actively engaged in the practice, and we have a chairman of the criminal section, and we have 2 other attorneys. So we have 3 attorneys because we have that volume of work, and some of it which I bring in from my experiences.
Yeah. And when you decided, okay, you know what, I'm going to go over to criminal defense, what was your thought process? What did you, what were the types of things that you were weighing? Because as an outsider looking in, it seems like switching from prosecution, which is going after people who are accused of crimes. As you mentioned, they're innocent until proven guilty, but your job is to try to convict them. Then you moved over to the other side and said, you know what, now I'm going to try to defend them. Was it an easy choice? Was it a hard choice? What were your decision points there?
That would be the first question most people would ask is, how can you represent someone accused of or charged with something so horrible like killing someone or raping someone? And I would often say, we don't judge people by the crimes they're accused of. We all have the benefit of our constitutional rights. And as an attorney, this is how I viewed my transition to becoming a defense attorney, is that we all are guaranteed a fair trial and due process under the law. And we have constitutional protections in place that afford us those rights, like the Fourth Amendment against unreasonable searches and seizures, the Fifth Amendment, the right against self-incrimination, the Sixth Amendment, the right to counsel and the right to confront your accusers. So we all are guaranteed those rights. So as a defense attorney, I never really said, hey, did you do it? That wasn't a question I would ask. I'd say we need to see if there's enough evidence on the state side to support the charge to result in a conviction of you. And if that was the case, then we would negotiate a plea deal, a plea bargain, which, has to happen in most cases, or the system wouldn't, quite frankly, be able to handle every case going to trial.
Right. And what you mean, and I know this from my true crime listening experience, is that that it might not go to trial. You might offer someone, hey, you can have a few years in jail and that'll be that. You don't have to go to trial. Is that what you mean by a plea deal?
Yeah, yeah. What means is that the charge may be downgraded or amended to reflect the actual crime that the evidence can support. And a lot of times it's about reducing the exposure, the imprisonment of an individual, going from a 20-year sentence to a 10-year sentence could be a huge benefit. Going from a 10-year sentence to a 5-year sentence could be life-changing, because someone may be eligible for parole after serving, a year and 18 months. So you have to look at that and knowing the parole guidelines and the parameters with respect to sentences, what is actual time that someone would get with respect to a sentence.
And so you'll look at the case itself and say, look, there's this evidence and there's that evidence.
Sure.
This is a good idea for you to consider this.
And just to explain it, I never really took off the prosecutor's hat. I always looked at the case with the same level of scrutiny as if I were a prosecutor. I'd say, well, this is what the prosecution needs as far as evidence. And is this evidence even admissible? Can it withstand a constitutional challenge? For instance, a statement, a confession. Was the individual properly Mirandized? Did they fully understand their rights? Was it a knowing and voluntary waiver of their Miranda rights where they gave a confession?
Right.
Perhaps no advisement of rights was given at all. Therefore, the confession would be thrown out. That would be a request or an application made to the court under the Miranda issue.
Yeah.
Evidence improperly seized would be a motion to suppress evidence and trying to keep physical evidence out that the police may have seized without a warrant and they didn't have the authority to do so. So these have to be weighed out. And those would be things that I would look at as a defense attorney and say, I think there's going to be some problems here, or I look at the evidence as a whole and I look at the police reports and I say, you know what, there's a couple of critical witnesses here that are mentioned in the reports, but they were never interviewed and they should have been interviewed. They're a critical component of the state proving this case. Sometimes I would tell the prosecutor and say, hey, you've got a bit of a problem here. Your case is not as strong as you may think it is. And, coming from me as a former prosecutor, I'd like to believe it meant something, but many young prosecutors got very, very offended or got their backs up when you come to them and you say, hey, I think you've got some problems with your case, because they're like, yeah, that's what every defense attorney says.
Yeah. They think you're after something. I want to talk about this idea of innocent until proven guilty. That is what we're all entitled to. But it doesn't really always happen, does it?
It doesn't. It doesn't. In fact, I think, quite frankly, the opposite, that when someone's charged or accused of a crime, it's almost like they're guilty until you can prove they're innocent. And that's not the role of the defense, by the way. It's always the state's obligation to support a conviction, and the burden of proof is beyond a reasonable doubt when it comes to a conviction.
Right. It's high.
So
that's high.
It's a high standard, correct.
Yeah.
It's very different than a civil standard, which is, in a civil case, when someone's a slip and fall or a motor vehicle accident and you're going after the individual or the corporation, whatever it may be, it's a presumption. That there's a preponderance of the evidence. So the preponderance of evidence is a much lower standard than beyond a reasonable doubt, which is a high standard.
And do you think that the role of, I'm thinking about all of the true crime shows, both on television, on podcasts, they're everywhere. Do you think these are helpful or not helpful to innocent until proven guilty? Like, is it the media, I guess, the media exposure that happens around all of these things that makes it a little bit harder?
Well, you know what? There is the court of public opinion, and sadly, a lot of people are tried in the press. They're accused of something, and before they ever step foot in a courtroom, they've been deemed to be guilty. And that's not really the way our system works.
Right.
But yeah, I do think that podcasts and all of the wave and the fascination with true crime has brought a level of interest and fascination to this area. And certainly, I'll say an understanding and an awareness. So people know about what happens in the system, so to speak, depending upon what shows they're watching, of course.
Yeah, that's true. So this innocent until proven guilty, this idea of innocence until proven guilty, why is it so important in our system? Why is it
Well,
like that?
because honestly, simply to be accused of a crime today, as in the past, it didn't really require much. And I think we could go back to the Salem witch trials and look
Mm-hmm.
at those women that were accused of being witches, and they were all killed.
Right.
And we know that that system was not really an effective system,
Correct.
and we've learned through the years, and we've changed and we've grown. But really, our system is based on English common law. We brought that over from England, and we kind of enhanced it and developed it over the years and made it our own. But it really is derived from English common law, our history and our traditions in law. And that's something that we hold very, I'll say, high, and it's valued and respected in our society, is that you are innocent until proven guilty. But sadly, people don't view it quite the same way, and many judges don't view it quite the same way. And it's
Really?
very difficult when you go into a case, and if it's a bench trial, not a jury trial, even a jury trial where a judge is making pretrial determinations, if they have a predisposition to believe that someone's guilty of the offense that they're charged with, it's very difficult to win motions or applications to the court. And it's very challenging to go to trial with that individual as well.
Mm-hmm.
Understanding the gravity of what they're dealing with, and what the charges are that they're facing possible imprisonment on, and really doing a very effective job as being a passionate attorney and arguing their cause or their case and their defense.
Right. So yes, we have this assumption of innocence until guilt is proven. It's really important for you as a defense lawyer. Has it ever been challenging?
Um, there were times, yeah, there were certain times I wouldn't take a particular case because someone wanted to come in and basically spill their guts and
Oh,
tell me everything, or somebody would request that I come to the jail and meet with them, and a family member would bring me into a case because their loved one was in custody, and after meeting with the individual, I might not particularly like what they had to say,
mm-hmm.
or look at the crime they were accused of, and look at what was the evidence in the case. And
Yeah.
I have to say, it became particularly challenging in sex cases with child victims.
Yeah.
Those were particularly challenging and very difficult. And I almost had to put blinders on to say, okay, regardless of whether you did it or not, I have a job. Ethically, I'm responsible to give you the best defense possible
Right.
under the eyes of the law.
But in the cases where you thought, I can't uphold this idea of innocence, you just wouldn't take it.
Well,
Is that what you're telling me?
no, it was a personal issue more so. It really was about like the individual or the crime or the
Mm,
evidence that I would evaluate and say, this is not a case that I want to be
I see.
handling.
Yeah.
And I was able to walk away from it. Having a private practice, I wasn't a public defender. It's
Yeah.
not like I'm assigned to a case and I have to take that case. I have the right to say, no, this is not a case that I want to be paid to represent someone to defend them.
Yeah. And now I'm going to talk about my only experience with the criminal justice system, and that is obviously true crime shows. And I would imagine that they're shaping sort of what they want us to see as they're developing these shows. Has there ever been a time in a trial where you think there's just the evidence is too overwhelming and maybe didn't realize it up front, but then eventually you thought it was? Because I watch these shows and I think that person's guilty. Like, how are you defending them? They're clearly guilty. Now I understand they're probably shaping things because it's television. They got to keep us hooked on the story. But there's certainly been times where I've watched where I've thought, I don't know that I could uphold the innocent until proven guilty, because it just seems like there's so much evidence right now.
Well, I would say the role of any good defense attorney is really to know exactly what you're up against and know what evidence that the state intends to bring in the case.
Yeah.
And, many times, sadly, and it's not trial by ambush. It's not like that at all. It's fully disclosed, except in the federal level. It's very different than in the state systems.
Oh.
The federal courts, U.S. attorneys don't have to disclose all the discovery up front right away as they do in the state system. So you kind of know going in what the evidence is and how you're going to attack it, how you're going to challenge the evidence, and perhaps cross-examine a witness and try to show that they're not telling the truth or that they are testifying inconsistent with a prior statement they may have given. To discredit them in the eyes of the jury. So many times you go into a trial and you don't know exactly what's going to happen. It's not like it's it's not like a Law and Order episode where it's got to happen beginning and end in 60 minutes because that's it.
Yeah.
It's not quite like that. So things do happen. I won't say there are surprises along the way, but definitely they happen in cases. Yeah. I talk about one experience I had in my book about me prosecuting a vehicular homicide case because all along the account was that the young woman had drank several pints of beer from this particular establishment. And, we all think of a pint glass. And that's what is served at a beer when you get a draft beer. They serve it in this glass.
Yeah,
and we
glass.
assume a pint is 16 ounces. So I stupidly did a demonstration in front of the jury because she had, I believe it was 5 pints. Yeah. And she was the designated driver and ultimately killed the young man that was in the car with her. And I brought in a can of soda, a 12-ounce can of soda, and thought for sure that I'll pour the soda into the glass and there's going to be 4 ounces remaining just to demonstrate that a pint is a substantial amount of beer for a young woman, especially at her weight, to have consumed over a short period of time. That was all brought into the case. Sadly for me, I did this demonstration, and as I poured the soda, it went right over the top of the glass.
Oh.
So
Yikes.
It was not a pint glass.
Yeah.
And so when you get a pint glass in a bar, you're really not getting 16 ounces of beer.
Wow.
And I found out the hard way.
Yeah, right? Good
Yes.
to know. I would be interested in hearing about a case where the innocence until proven guilty really did, stand up in the case, like where there was evidence, but it wasn't, the person was clearly not guilty, that we needed that innocence until proven guilty.
One case particularly comes to mind was a young man that was accused of a date rape. And the young woman who was graduating high school, and he was in his first year of college, but they had a connection to each other. They knew each other, but she had claimed that she was too intoxicated. She had voluntarily consumed 6 White Claws over a period of about an hour and a half. And then she went to sleep in the same bed with this young man and claimed that he engaged in sex with her without her consent, that she was too drunk to have given consent. That was the case. And he was arrested, and he professed to me, and he was locked up, and he sat in jail, and that's a whole nother story, but he maintained his innocence, and I fought very hard to get him out of jail. He was in jail for over a year and a half, and I predicted that there were a lot of flaws with this case, and ultimately the charges would be dismissed against him. That was my prediction from the beginning. I said, but when that's going to happen, I can't tell you that. I don't control the system and the process. Right. He sat in jail for well over a year. And as we approached a year, and I went through a number of pretrial related issues to try to get him out, I was substituted out of the case for another attorney. Another attorney took over the case, and he got a substantial retainer. And I had gone to the appellate courts to fight to get this young man out. I just didn't believe that he belonged in custody. And I became a de facto psychologist because I was literally talking to him every night from the jail on the phone, just trying to calm him down and say, listen, just hang in there. It's going to be okay. He was beside himself. He was ready to go into his second year of college.
Yeah.
And this young lady that was the victim in the case went out and decided that she was going to become an escort. And I found this out and I disclosed it to the prosecutor. I said, through my private investigator, I have all this information about what she's doing. And this is going to affect her credibility as a witness. And you should know this. They didn't want to hear it. They thought I was victim bashing and that, I was just trying to discredit this young lady. And I said, ultimately, yes, it's something that the jury will have to consider at the end of the day. Well, what had happened was, this was after I had been off of the case, is this young woman had engaged in a sexual encounter with a married man, and she tried to extort money from him. And he became violent with her and physically assaulted her, and then she stabbed him.
Wow.
And put him in the hospital, and lo and behold, the case disintegrated and the young man was released.
Wow.
Yeah, and it took a year and a half of him being in custody.
Yeah.
It was a very, very troubling case on a lot of levels.
And if you're in custody for a year and a half and the case is dropped, oh well, right? Does anything happen?
Well, I mean, you may have a case, a civil lawsuit, for a false arrest or false imprisonment. That's a very difficult standard because most government actors, like prosecutors and police officers, have immunity. They're immune from prosecutions unless they act in bad faith. In other words, they knew that this individual didn't commit the crime, and there was something very obvious and apparent to them that they should have known or did know, and they chose to ignore it. Then there would be civil liability for him sitting in jail. But, that I've heard of cases and read in the book Framed by John Grisham and I believe Jim McCullough. So it's just released last year, about 10 real life cases where people were wrongfully arrested, accused, arrested, convicted, and actually served long sentences. And it turns out that they were wrongfully convicted. And some of them actually did get monetary awards from the state because they did not disclose evidence or they withheld evidence from the defense. There were deliberate actions on the part of the state to try to go forward and to prosecute these individuals. Or they used jailhouse snitches that were not reliable witnesses, and they knew that they were not reliable and credible, and they didn't disclose the other part of the story.
Yeah. So let's talk about that, because I have a feeling that probably comes into your thought that the scales of justice are not balanced. I want to hear your thoughts on that. From you said that you learned a lot as being a criminal defense attorney from being a prosecutor, and it opened your eyes a bit. Sure.
Well, here's the cover of my book. I should probably show that because we're really on the subject. You can see it's Lady Justice is blindfolded, but she's peeking out from under the blindfold, and the scales of injustice are somewhat imbalanced, and Lady Justice is supposed to be blind and justice is supposed to be equal. Yeah. And my view of it was that it was not quite frankly that. Lady Justice was peeking out from the blindfold and trying to tip the scales. And my argument and what I said in the book is that it was, in my opinion, is that it was tipped in favor of the state and the prosecution rather than the defendant. So I felt that my transition, I learned a lot being a prosecutor because I really learned about the responsibilities of what a prosecutor needs to do, which is to seek out justice. And I didn't feel like that was happening in every case. It wasn't about getting a conviction, and so many prosecutors were driven by conviction rates. Not about looking at the evidence and determining whether it was just to convict an individual or not. So becoming a defense attorney was a logical transition, and looking at it just pretty much the same way, but saying, it's different now. Now I represent someone that's on the other side of this, and I have to look very closely and scrutinize this because there's a lot at stake.
Yeah. And what are some of the examples of the scales of justice being a little bit tipped when you say that it works more in favor of the state? Why?
The logical thing that I would say is the resources that are available to the prosecution, in terms of investigations and expert witnesses and things like that. They have resources that the defense does not have. And many times I was limited by the financial wherewithal of my clients. I would be retained in a case, and the retainer was X, but if he went to trial, it was Y. And many times what would happen would be that the case was exhausted and prosecutors employed a system wherein they were wasting unnecessary time going back to the court and claiming that, well, we haven't completed our investigation and there's additional discovery that's owed to the defense in the case. We're waiting on this witness. We have to interview this witness. We're going to get an expert in the case. Every time those delays happen and you go to the court with your client, that's a delay.
Yeah.
And ultimately, it's costing that client money. And what would happen is that this would be employed so much so that towards the end of my practice era, in my private practice, clients would run out of money. They just did not have the money to support litigation. And then, of course, they had another amount to pay if the case went to trial, and they'd say, I don't have any money. I can't pay you. Yeah. Well, the logical thing is that the attorney has to get out of the case and they have to file a motion to be relieved of counsel. And that was happening more and more as time went on. And I think, quite frankly, the COVID era brought that out because the system kind of bent over backwards just to keep the cases moving, just keep the ball moving so that we don't have this tremendous backlog when this is all over with. And many people's constitutional rights were sacrificed and compromised during that time, especially when it came to detention hearings. People were locked up and they were to be in front of a judge to have their situation reviewed, whether they would stay in pre-trial or they would be released. And by and large, courts were not releasing people when they were charged with serious offenses simply because they were charged with them, not because there was evidence to support the charge, simply because they were charged with an offense that carried a significant period of time of imprisonment if they were convicted. And I've had many of those clients. In fact, I had 7 clients in jail at one time.
Wow.
Yeah.
That's a lot.
It was a bit overwhelming.
Do you feel like if for people who are accused today, do you feel like they still can get a fair trial?
I'm a little bit jaded. I have to say it depends, and I say that with a grain of salt because it depends on many things. I mean, It depends on the judge. In the case, is the judge neutral, unbiased, and detached? Are they looking at this case the way it should be looked at? Do they have a conflict of interest?
Right.
Is there an inherent conflict of interest where a judge should not be presiding over a particular case? The prosecutor, is the prosecutor equipped to do their job? And oftentimes I looked at that with a very close eye and scrutinized that from my experience. And I'd say, are they equipped to represent the state in this case? In other words, are they interested in justice? Or are they simply going to follow marching orders and come to court and say, hey, your client has to go to prison? Your client has to go to prison without ever really looking at the file and looking at what the evidence is and whether or not the evidence supports the charge.
Right.
And it wasn't my job to become an educator to the prosecutor. I wasn't a mentor to the prosecutors, but many times I found myself speaking to them and saying, hey, I did your job and that this is not quite how I would have done it, but I'm not going to tell you how to do your job. But I think fundamentally, these are things that need to be looked at.
And I know you've said before that that sometimes, the investigators or whoever's looking into the case, they think, okay, we found our person, and they just go with it and they stop looking at the other possibilities.
Correct.
And so that
happens
becomes
many times that happens where there is another suspect and they just don't, once they've made the arrest, they're committed to that arrest, and that's the individual that's got to get convicted. And then they get the prosecutor in line and lockstep with that thought process. And the prosecutor buys into that. And that's kind of some of the chapters of the book I just discussed. They talk about that, where the police have convinced the prosecutor that, hey, this person needs to be convicted. And they'll put a square peg into a round hole to make that happen.
Do they not have any legal implications on that? Like, are they supposed to exhaust all avenues?
Well, legally, if you're asking me the function of the police, if that's their responsibility, well, I would say they need to do a thorough, complete investigation in every case. Does it happen? No. Sometimes they do lock in on a suspect and they believe they have ample evidence to support the charge. And then we get to the different levels of proof. Probable cause is the level that constitutes enough evidence for an arrest. Probable cause is a very low standard on the bar. It's the lowest standard. Probable cause means probably a crime was committed and probably this individual committed the crime. Versus the beyond a reasonable doubt, which is the standard after a trial that a jury has to find someone guilty of.
Which is a high bar.
Very high bar. So they may just look at it and say, hey, we have enough evidence to arrest this individual, but they don't go to that next level because they say, you know what? That's not my job. That's the prosecutor's job.
Or I can see if someone was at the scene and they had a weapon. I can see you thinking, well, this is obvious. Let's move to the next step. But
sure,
maybe sometimes there could have been another person and another weapon. Who knows?
Well, that certainly has been the situation in cases for sure. Charging the wrong person simply because they were there at the scene or at the location, wrong place, wrong time. Yeah, that's happened.
Well, what do people, from your vast experience in this criminal legal system, what are some takeaways that the average person needs to know?
Well, I think we were talking before, and I think the average person's encounter with police is very different than, an actual arrest where they're brought into an interrogation room and there's a custodial interrogation for a serious criminal offense. Although that does happen, sadly, to people and that they do commit crimes and they are brought in by the police. And that's the way our system works. But most people, everyday, ordinary people, their encounters with the police are at the roadside for traffic offenses. The police pull them over for speeding or running a red light or going through a stop sign. And what I tell people always, without question is you will not win your case arguing with the police on the side of the road. That's not going to happen. I can guarantee you that will not happen. And I can guarantee you another thing. It's not going to go very well for you.
Right.
You have to respect the law officer, their position, take your summons and get out of there. And then you can fight it out in court, but don't try to, defend yourself on the side of the road and say you didn't do it. They shouldn't be charging you. So many times that happens. And unfortunately it escalates and it gets to a very different level.
Yeah, that makes sense. And then, since we've talked a little bit about true crime, everyone's sort of window into your world these days, when people are watching or listening to true crime, what should they know from your perspective?
Well, I think that some of the true crime shows actually bring it out, which is to know your rights. Absolutely know your rights. And your right to counsel is very important. And so many people think that they can outthink the police and they're going to talk their way out of their problem. I don't know that really happens. Generally, when you're brought in for questioning, there's probably enough evidence already to arrest you. And it's not like the police are out there looking to, exonerate you. Clear you. I mean, that does happen. It does happen where you give a statement, the police say, okay, I'm pretty convinced that you weren't involved and I'm going to let you walk out the door. Yeah. But the lion's share of those times, you're not leaving that room once you enter it. So you better think about that and think about exercising your right to an attorney, know your rights. Right to counsel is so important. And also having a good, effective attorney that's passionate. And what I mean by that is somebody that really cares, that is going to be in your corner to fight for you. And that they have the experience in the background to do their job. And that's part of the interview process when you're hiring an attorney. It's not, hey, how much are you going to charge me?
Right.
That's certainly a good question, but not the first question.
Yeah. So it's what have you done?
Yeah.
Well, James, thank you so much for joining me on Tell Me What It's Like. This has been a fascinating conversation and look into the criminal defense system.
Well, thank you so much. It was a good conversation, a lot of good topics and a lot of good discussion.
Thanks to James Porfido for telling us what it's like to move from prosecuting accused criminals to defending them. Next week, Julie Melanson on what it's like to be an adoptee and to find your birth mom when you're 51 years old. I'm Stacey Rain. Thanks for listening.